Hello and welcome to Bar 10, where it's our goal to help you prepare for the bar exam. To that end, we upload content regularly with regards towards questions for the MBE, regular law school preparation, admissions into law school, and everything law school that you can possibly imagine. My name's Carlos, and I'll be your representative from Bar 10 today. Let's get started with a review of quite possibly my favorite book during my law school time. The book is entitled Getting to Maybe. Perhaps you're familiar with it. I hope that you are. If you're not, we're going to introduce you to it. And if you're already familiar with it, we're going to see how to put it into practice, in fact, and if it's actually a valuable resource for future practice as opposed to just your law school experience. The entire book's, in essence, an issue spotting treatise. It, in essence, explains the fact that you must spot issues. And once you spotted issues, you can then begin to analyze, or you can take the next subsequent steps, which the bulk of the book is designed to do. It starts off with explaining that you're not in Kansas anymore, and you're absolutely right. They're absolutely right. Law school and undergrad are two completely different animals. The law school experience for most people is extremely intimidating. It's frightening. It's every negative thing that you can possibly imagine. And that's usually for the first year. It slowly dwindles after that. Second year, not so much. Third year, you're just really itching to get out and looking forward to get into practice as opposed to living in this imaginary practice world. Part of the issue with the law school experience is that, in fact, it is in an imaginary world, much like the Wizard of Oz. You have this fictitious world where the law and or items and facts that you learn, for the most part, will not be useful. Hence, my experience is that law school textbooks are quite possibly the most useless books you'll ever have. So my experience dictates to me that you should be renting them rather than buying them, because the value of them will be a very negligible percentage of what they were when you purchased them, subsequent to your semester ending. And the likelihood of you ever using them again is as close to zero as you can possibly get. That being said, the majority of this entire book is on something called forks. They, in essence, describe any division or different treatments or possible skew as a fork. The forks are, in essence, where your answers should be focusing based on the authors. And in essence, what that means is that you should ultimately be looking at facts or law or anything in between, and ultimately making a decision in your writing to go both directions on possible forks in facts, forks in law, forks in statutes, forks in treatment of statutes, forks in public opinion, the multitude of forks that it ultimately describes within its pages. You can break it down to something relatively simple, and the idea simply is that ensure that you analyze both sides or all sides of a story. That story could include facts, could include law, could include treatment of law, could include a multitude of items. Just ensure that in your answer you are in fact presenting all of the possible sides to a story. The idea with law school exams for most people is that they walk into it thinking that they have to make a decision and they have to choose who's right or wrong, and they have to give a correct answer. The truth is that the correct answer portion of it isn't as valuable as you would think. The reality is that the analysis portion of the exam is really where the points lie, and ensuring that you're able to spot all of the different issues and properly analyze them. If you were to do that and get the ultimate answer incorrect, which would be very difficult because, as the book tells you, your ultimate answer really should be an if answer. So, i.e., your answer should be more like, if this is true, then that. But if this is true, then that, as opposed to you should have finality in your answer, meaning that Dennis is absolutely guilty of the crime charge. That those should not be your responses on any law school exam. They should be more so of the nature of, if Dennis was in fact found to be in possession under the statute, then the likelihood is that he would be found guilty. However, if he were to not have been found guilty of possession, then perhaps secondary issues or secondary statutes would come into play. Then there may be other elements, perhaps, that he might have to meet. But ultimately, you should be addressing every single question, much like we just did with this fictitious criminal question, i.e. being, let's say, for example, if there are elements to a crime, did the person did they do or did they not do each of the elements of the crime? And you should analyze each element as to whether they did or did not do. And in essence, make a presentation almost as if they could have or could have not, and give an explanation as to why it could be deemed that they violated or met this element of the statute and why it could be deemed that they did not. That being said, ultimately, if you read through the book, there's a multitude of different types of forks, as previously noted. But the reality is that once you review the material for your course, whichever course you're looking at, your professor, as well as your reading, is going to make it relatively clear what the forks in the road are, what the possible deviations or what the possible options, and more importantly, your professor will make pretty clear what the specific things that he or she likes to test or what the specific questions that they deem are more relevant to the particular course you're taking. Let's move forward and let's do a sample question ourselves. This is a constitutional law question, as you can see. I'm going to read it out to you. You can read it for yourself as well. The next question vividly illustrates why merely memorizing laws and cases won't be enough on law school exams. Virtually every constitutional law student learns the framework in which government classifications that discriminate on the basis of race receive strict judicial scrutiny. Those based on economic factors receive rational basis review, and those based on gender arguably fall in between. But the following question tests not merely the familiar framework, but also the more fundamental issues of what constitutes discrimination. The question also attempts to place a set of facts between two cases, another example of a competing domains problem. Finally, the question involves both structural issues involving the separation of powers and individual rights issues involving equal protection. Unless you follow Chapter 9's advice to continue past the first issue you see, which is a point they made rather clear, that you shouldn't stop just at the first issue or the first question or the first fork that you see. You should be looking for as many as you can because the likelihood is your professor included many. Here we go with the question. After Al Gore is elected president in the year 2000, William Rehnquist resigns as Chief Justice of the United States. President Gore nominates Mario Cuomo to replace him. 60 U.S. senators sign the following letter to the president. Dear Mr. President, we believe Mario Cuomo is eminently qualified to serve as Chief Justice. We will not, however, vote for his confirmation. It is our sincere belief that the time has come to have a woman as Chief Justice of the United States Supreme Court. We will not vote for a man to fill that position. We urge you to withdraw the nomination. President Gore refuses to treat the senator's letter as a final word. He makes an impassioned plea to the public and the Senate that Cuomo is the person for the job. Finally, Gore and the new Senate Majority Leader, Paul Wellstone, work out a deal. The Senate agrees to reconsider the Cuomo nomination in exchange for Gore's promise to sign the Rotating Gender Chief Justiceship Qualification Act of 2001. The act reads as follows. The President shall not appoint, nor shall the Senate confirm any person to serve as Chief Justice of the United States who is the same gender as the person previously holding that office. After Cuomo was confirmed, the Congress passes this measure by large margins, and the President signs it into law. Discuss all possible constitutional challenges to the statute. Will it survive constitutional scrutiny? Why or why not? This is a relatively complex question addressing a very real issue. While unfortunately most of us in practice will not have questions like that presented before, however, the likelihood is that you will have very complicated questions much like this, which involve not much of a black or white situation, but in essence, a very gray area. As the answer now begins to tell us, there are no easy issues here, so a good answer will launch right into the thick of it. Here's what one might look like. It's not immediately clear who would have standing to challenge a statute like this, since presumably someone must show an injury in fact. Eventually, however, a president may wish to nominate someone of the gender disallowed by the statute, and that person might have standing to sue. I'll assume for the purposes of the question that someone has standing. That's a very key issue. Remember, you're being asked to discuss this particular statute, and the reality is that until there is standing to bring a claim, the likelihood is that no court will touch this. One obvious problem with the statute is that it's a legislative as opposed to constitutional change in the framework of our government. The Constitution clearly gives the president the power to appoint a Chief Justice, and it's not all clear that his options may be limited by statute. There's a strong analogy between this case and U.S. term limits versus Thornton, in which the Supreme Court invalidated Arkansas's effort to put an additional qualification, i.e. term limits, upon those seeking to appear on the ballot to be elected to the House and Senate. On this theory, the additional qualification that the new Chief Justice be of the opposite gender must be added by constitutional amendment. Defendants of the statute might start by noting that limiting president's appointment power may not be the same as imposing a qualification. Certainly, statutes can create federal offices and require the president to choose individuals of different political parties. True, the office of the Chief Justice is based on the Constitution, not just statutes. But suppose a statute requiring president to select a lawyer. Would that be an unconstitutional infringement on presidential prerogative? So then the statute's defenders might point to the standards set out in Morrison versus Olson for judging the constitutionality of statutes that limit the president's power to remove certain executive officials. In Morrison, the Supreme Court said that the president's removal power could be limited as long as there is no impediment to the president's ability to exercise his or her core executive functions. Here, the argument would be that limiting the president's choices by gender would hardly be overly restrictive, since there are plenty of men and women qualified to serve as Chief Justice. Indeed, it might be said that the president won't suffer any real limitation at all. The analogy to Morris, however, is probably not as strong as to the term limits case. First, Morrison is about removal, a topic not clearly mentioned in the Constitution. The Rotating Gender Act puts limits on appointments, a matter clearly spelled out in Article 2. Second, Morrison dealt with independent counsels, whom the court clearly determined were inferior officers under the constitutional definition. Obviously, there's no more important office subject to presidential appointment than the Chief Justice, so the court might be more concerned with a statutory limit on presidential authority. Third, the Senate's advice and consent power is clearly the constitutional means for the Senate to have its say over presidential appointment of judges. This statute alters that constitutional mechanism. For all these reasons, I doubt the courts would undertake a qualitative assessment of whether the president's prerogatives were unduly limited and rely instead on a formalistic approach prohibiting statutory modification of the power to appoint constitutional officers like the Chief Justice. A second, unrelated challenge to the Rotating Gender Act would be based on the equal protection component of the Fifth Amendment. Equal protection of the 14th Amendment applies directly to states. The Supreme Court has held that the same principles applicable to the federal government through the Due Process Clause of the Fifth Amendment. The Supreme Court has gotten increasingly tough on government. Classifications based on gender, although such classifications don't yet receive the same strict scrutiny as racial classifications, the court requires government to demonstrate an exceedingly persuasive justification. I doubt the statute here could survive that test. Presumably, the government will defend the statute on the ground that it will help remedy past discrimination. There has never been a woman Chief Justice, and on the ground of promoting diversity on the court, it's not clear that alternating the gender of Chief Justices achieves meaningful diversity on a 9-member panel. But in any event, cases in which the court accepts diversity as a rationale for race, and thus presumably gender-based classifications, tend to be those involving education. Bakke, for example, Regents of University of California versus Bakke, or the media, Metro Broadcasting and Inc. Versus Federal Communications Committee. Commission, my apologies, extending the diversity rationale to permit gender quotas in constitutionally significant governmental bodies like the Supreme Court seems inconsistent with the court's direction of rejecting even much more limited affirmative action programs. See Adord and for the remedying past discrimination. The statute's most obvious flaw is that half the time it will require naming a man. Beyond that, even past discrimination hasn't justified rigid quotas. Baki, the total number of people who have filled the post is so small as to make proving discrimination difficult. And the statutory requirement is permanent rather than merely remedial. All this leaves the statute on very uneasy footing. The government might also argue that the statute shouldn't be evaluated under the typical standards for gender-based classification, because previous cases involved situations where the classification favored one gender over another. Here, the statute merely calls for rotation. There is no discrimination, and thus the government could argue for a rational basis test rather than intermediate scrutiny. Even cases like Craig versus Boren involved discrimination against men, whereas here, over the long term, the statute can be characterized as a gender-neutral statute. In theory, this is a strong argument, but based on what I know about constitutional law, there's no obvious way to decide whether the right time frame is at the moment of choosing one particular Chief Justice over the long haul. In practice, however, I doubt the courts will accept it. It would pave the way for all sorts of gender rotations, and worse still, racial rotations. Could a statute say every sixth Chief Justice must be African American? And the courts seem committed to the idea that job selection should be based on criteria other than race and gender. For this reason, too, then I believe the courts would find the Rotating Gender Act unconstitutional. This is a sample answer. You can find that towards the very end of the Getting to Maybe book. And ultimately, let's backtrack a bit and let's go back to the question. Let's see if we can address the forks in the road that the book, in essence, mentions. So let's get started with the question itself. Al Gore is elected president in the year 2000. William Rehnquist resigns as Chief Justice of the United States. President Gore nominates Mario Cuomo to replace him. 60 U.S. senators signed the following letter to the president. So they signed this letter. Now, we immediately realize there is a letter. There is something which is requesting the President of the United States not to take action. Perhaps we can commence with a fork in the road of being that letter is either valid or invalid, and what the weight that letter should be held, or should be what weight should be given to that letter, better said. Subsequently, we look at President Gore refuses to treat the senator's letter as the final word. He makes an impassioned plea to the public and the Senate that Cuomo is the person for the job. Finally, Gore and the new Senate Majority Leader, Paul Wellstone, work out a deal. The Senate agrees to reconsider the Cuomo nomination in exchange for Gore's promise to sign. Now, we're left with a question of, would the president be permitted to do this? What authority grants him the ability to do this? And what would be negative authority here? So that is what I would at that point be looking to address. Subsequently, we're looking at now the remainder of the question, which the president shall not appoint, nor shall the Senate confirm any person to serve as Chief Justice of the United States who is the same gender as the person previously holding that high office. After Cuomo is confirmed, the Congress passes this measure by a large margin, and the president signs it into law. Now, you can address that entire process. Now, we're looking at the president shall not appoint, nor the language of the statute is the president shall not appoint, nor shall the Senate confirm any person to serve as Chief Justice of the United States who is the same gender as a person previously holding that office. Now, we could look at that as violative of the Constitution or not violative of the Constitution. And if it is violative, what amendments would it be violative of? Obviously, we could think of, as previously noted, discrimination or, in essence, procedural issues such as under the 5th and the 14th Amendment. We could look at those. And I don't know that there would be much else, as previously noted in the sample answer, but I would analyze it on the premise that it could be valid or invalid under both, and why, and explain why and what the arguments for each side of that exchange would be. Now it asks you to discuss all plausible constitutional challenges to the statute. In essence, that's what we would have done. We would have broken down this question bit by bit and addressed every possible constitutional malady present. I believe that if you attack every single law school question in exactly this way, you will be able to improve your law school writing as well as your research and your ability to present an argument overall. In essence, this is the way you should be thinking as a practicing attorney subsequent, or simply taking advantage of the legal education that you're receiving in law school. So ultimately, what Getting to Maybe is attempting to teach you, and we'll place that back up, what the two authors, Paul and Fischel, are trying to teach you is relatively simple. It's trying to teach you that you must look at every single angle of a problem. And I know for a fact that some of the best writers that have gotten phenomenal grades on the essay portion of the bar exam have done so more so simply because they've looked at the questions from every possible angle and addressed every possible angle. Key things to remember or to take away from this book also are that ensure that you also note why the negative isn't also true. And by that I mean, for example, let's say the fact pattern comes close to describing a violation of a particular statute, but in fact does not. And you opt to not discuss it in your writing simply because, in fact, on its face, it is not violative of that particular statute. But the mere fact that it comes close to that statute or addresses some of the elements of that statute, perhaps it's something you should discuss and bring to the attention of the reader that you, in fact, are aware of this. And you're aware of the fact that this particular fact pattern, but for missing one or two items or facts, does not fall into this particular statute. And obviously what we're talking about here is differentiating the question here presented with some of the materials that you've looked at in class. What I will tell you is that the majority of law school professors will in fact want to note that you've picked up on the fact that some of this material is rather close and there is a little bit of a gray area, and perhaps some of the material, you're not going to be able to discuss all of the material in relation to every single question that you're presented to in a law school class. That would be virtually impossible, and that's not what you would want to do. You wouldn't want to, in essence, regurgitate the material that you receive. But what you might want to do is, while not excluding every single topic that was presented to you in the course or in the course book, the topics that come remotely close, you might want to address them and note why they might be excluded from your rationale. That being said, Getting to Maybe was a fantastic book. Fischel and Paul did a great job of presenting a logical way of attacking law school questions. In reality, it's something that I know many people have used for many, many years subsequent to the practice, subsequent to the completion of law school. And many people that I'm aware of in practice actually also still use exactly the same logic, and people that I'm aware of as well that are on the bench also follow the same logic. If you look at now, we have phenomenal resources such as Westlaw, which has a judicial portion of it. It makes life rather easy. We don't necessarily have to look at all of this analysis because Westlaw will literally just simply do it for us as we input distinct PDFs. But the judicial version of Westlaw is phenomenal. You can input both sides or papers on both sides of a question or of an issue, and Westlaw will now pick up the issues that were missed or that were misaddressed by each of the parties, and in essence give you a report printed out which one could utilize in reaching a decision. But at the end of the day, there's no substitute for actually being able to do going through the logic and being able to do the rationalization oneself. And I believe very strongly that Getting to Maybe is a first start in doing exactly that. So I wish you the best of luck. If you have any questions, don't be afraid to send messages or to post on this video. Look forward to seeing you again. Have a great day.